I'm joined now by Michael Waldman. He's the president and the CEO of the Brennan Center for Justice, which published that report about which we just spoke. He's also the author of the books, The Supermajority, The Year the Supreme Court Divided America, and The Fight to Vote. Also, Charles Coleman Jr. is a civil rights attorney, a former prosecutor in Brooklyn, New York, an MSNBC legal analyst, and the host of the Charles Coleman podcast, and a guy I'm not really often in the same room with, because if he's here, I'm not, and if I'm here, he's not. So it's nice to actually have you here. Michael, thank you for being here. This was a remarkable report in that it shows us what many of us thought might happen when we first saw this develop 10 years ago. One of the findings of the study is that in the past couple federal elections, millions of non-white voters have essentially been lost from the system. Tell me what the correlation is on that. Is it that the system became harder for them to vote, or protections for their vote were lost, or impediments were put in?
Yes, absolutely, especially in the states that used to be covered by the Strong Voting Rights Act. There have been a wave of new laws making it harder to vote. Some are worse than others, but they accumulate. And especially if voters are not used to voting, if they're new voters, they get discouraged. We don't know all the mechanics, but the facts are very clear. The racial turnout gap, the gap between participation by white voters and voters of color, it's grown all over the country for a bunch of different reasons, but in those states that used to be covered by the Voting Rights Act, it's grown much faster, and that suggests these voter suppression laws actually do suppress the vote.
Interesting, though, because in these days, voter suppression laws don't have to be as explicit as they were in 1870. They don't have to target black people. They can target zip codes. They can target states where you think the majority of voters who come out to support a particular party will be of color. Georgia's a perfect example, where you can't take water to people, standing in line. They know where the lines are. They know who's standing in the lines, where you can't drive people from church to vote. They know what they're doing.
Right. I think that it's important to understand that that's one of the reasons why data is so valuable, because now in 2024, with the sophistication of how we can break down data and understand how it functions, it has enabled this sort of exclusivity around democratic systems. Let's be clear about something. Black people in America have protected, have promoted, and participated in democratic systems unlike any other ethnic minority in this country. And for many years, we're only outvoted by white voters by a very small margin if you look at it. What we are looking at right now, Ali, is the intersection of a perfect storm around the law, around a very, very bad narrative around what democracy has and has not done for black people in America, and around an influx and a very, very high piece of white grievance pushing a strong majority of white voters to the polls in a different way. And this is a bad place for democracy to be in.
Let's talk about this concept of pre-clearance, because we talked about this a lot many years ago, and then that conversation's gone away for a lot of people. From your study, it writes, we find the gap has consistently grown. This is the gap between white and non-white voters since 2012, and is growing most quickly in parts of the country that were previously covered under Section 5 of the 1965 Voting Rights Act. The turnout gap grew almost twice as quickly in formerly covered jurisdictions as in other parts of the country with similar demographics and socioeconomic profiles. That's the part of the phrase that interests me, with similar demographic and socioeconomic profiles. So in other words, it's literally in the places that had serious voter restrictions or impediments that have sprung back into those things. In the rest of the country, where there may still be voter segregation or demographic segregation, it hasn't been as bad.
That's right. Those parts of the country that were subject to preclearance, these were places that had a history, demonstrated history of racial discrimination in voting. And the idea was you had to get permission in advance. And it turns out, as they say, conscience is the idea that someone somewhere may be watching.
Right.
They held back from doing some of the small things, closing polling places, or redrawing district lines, or passing discriminatory laws. But now these things can happen without the scrutiny, basically, of the courts or the federal government, and that has accumulated. And, you know, one of the things that's important here is this study was done by a team of political scientists over many, many, many months, using 1 billion voter files, real records. This is not speculation. There's a cynical view that you sometimes hear, oh, these laws, these practices don't matter. This shows that it actually does matter, and the progress we were making, unfortunately, is getting reversed.
Charles, let's talk about that concept of someone might be watching. One of the reasons people didn't worry so much about preclearance going away was two things. They thought the problem had been solved in many cases, and certainly what we've seen in the last couple of elections certainly hasn't been solved. And this idea that someone doesn't need to be watching. We've been far enough away from the Voting Rights Act that habits have changed, and we don't do that. I'm going to put up a map of states that have enacted restrictive voting laws since this came down in Shelby County v. Holder. Wow. Is all I got to say.
You know, the naivete of the Supreme Court, particularly Justice Roberts, if you go back and read the Shelby decision, is very disturbing because it strikes as being incredibly out of touch. And we're seeing it manifest. So much of what many of us knew when we read that opinion and that decision after Shelby, when it talked about the remnants of what was in terms of the need for the Voting Rights Act no longer being the case and no longer being necessary, it made every one of us who knew better say this is going to be a problem, and now we're seeing it. But more importantly, I think it's also important to understand the study succinctly lays out what the solution is. Pass the John Lewis Voting Rights Act and get this thing before it gets even worse. I think that anyone who claims to care about democracy, about voting rights, if you're a legislator, and you're looking at this, it's not enough to say this is terrible. It's not enough to say Section 5 is gone, Section 2 has now been gutted. That eliminates the notion of redress for private citizens and puts that in the hands of federal government. You can, as a Congress, do something about this if you really care about it.
Right.
And that's the scary thing, is because we're not seeing that happen yet. And so how invested are you really in democracy if you're not willing to codify it and stop this madness before it gets worse?
Congress can act. It has to have the political will to act. There was a majority, the John Lewis Voting Rights Advancement Act and the Freedom to Vote Act, which was national standards, passed the House and had a majority in the Senate. But the filibuster blocked it, just as in the earlier era.
Right.
Senators need to have the political will to say, you know what, we're going to fix the Senate rules so this bill can become law and restore the promise of protection for a multiracial democracy.
I think it's interesting because probably this particular Congress isn't going to be the one to take that up again. But usually we see things like this die in Congress, in the House, not in the Senate. Mm-hmm. Your point is very valid, that if we can get a Congress that will pass this and do it again, the Senate can do the right thing. And thanks to your study that proves that this wasn't conjecture on the part of Charles and others who said this is how this is going to go. I appreciate both of you being here this morning. Thank you so much. Michael Waldman is the president and CEO of the Brennan Center for Justice and Law at NYU Law, and the author of multiple important books, including The Supermajority, The Year the Supreme Court Divided America, and The Fight to Vote. Charles Coleman Jr. is a civil rights attorney, former prosecutor in Brooklyn, and MSNBC legal analyst and host of the Charles Coleman podcast.